Hello, it's Saturday, February 24th. I'm Michael Paris. This is a supplemental lecture for Political Science 321, Race, Law, and Public Policy. And this presentation, which is matched with a PowerPoint that I'll send along with the link to the video, and the slides are numbered, is about the Dred Scott case and the history and legal issues in the Dred Scott case. And I just want to get some of the background issues out of the way in this format. On the PowerPoint, you'll see there are 34 slides. I'm going to be referring to these slides throughout the presentation. And you should note there are animations, which means you have to click to see the full slide, and they're in there. And I don't have the animations for me. I have the full slide, so you'll have to just click through as we go. So on slide 1 is the title, and you'll see if you click twice, a painting of Dred Scott and a photo of Chief Justice Roger Brooke Taney, and again it's pronounced Taney, not Taney. And here on slide 2 you're going to see an outline. So what we're going to be covering are 3 different perspectives on the constitutional law of slavery in the U.S. territories, the very, very complicated facts and procedural history of the Dred Scott case, and things are way more complicated than we can get into in this presentation, but they're pretty complicated. And then I want to preview and just highlight some questions about Taney's opinion for the court in the case, and some questions we're going to be thinking about. Should we blame the Constitution or should we blame the judge? That's another way of saying, is he offering plausible or even the best interpretation of the Constitution that he has before him? Is what he is saying about the meaning of that Constitution plausible? Does he make a strong argument for it? Or is he clearly motivated by a political bias, a pro-slavery bias, to reach issues and resolve those issues in a way favorable to the South in this brewing conflict that will be, result in a bloodbath very soon after the decision? Another thing to note is there are 2 issues in the case as Taney frames them, right? He doesn't have to frame the case this way. He could have handled it many other ways, but as he frames the issues, could any African American person, whether emancipated or not, be a citizen within the meaning of the Constitution? That's the first issue. The answer is no, and he makes an argument for that. We want to know what that argument is, and we want to evaluate it. Second issue is, does Congress have the constitutional authority to ban slavery in territories that are not yet states, but territories controlled by the United States of America? Where would it get that power? And his answer to that question, quite controversially, is no. Congress cannot ban slavery in the territories, so when it purported to do so in the Compromise of 1820, the Missouri Compromise, it acted unconstitutionally. Right? And we want to know what the argument is for that issue. In the excerpt you have, again, we come in the middle of that second issue, that second discussion, without warning. It's on page 244 of your excerpt. You'll see a transition, and I'll have to fill that in a little bit because the editing isn't perfect. It's a fine excerpt on the first issue, which is why I use it. Okay, so slide number 3. If you click through the animations, we're going to start with 3 views of Congress's power to govern the territories with respect to slavery. So let's begin with a general point of agreement. Dred Scott itself might have called this baseline agreement into question. There might have been an implication of the Dred Scott case that people could travel with rights to own slaves throughout the United States. But for all of the history of the country, all white people who had power assumed that on the question of slavery, states were sovereign. Right? States can decide to have slavery. If they do, they can decide what the local law of slavery will be, or they can, as northern states did over the first generation of the Republic, after the Revolution, decide to abolish slavery, right? Render it null and void, ban it. That's the starting point, that slavery is a question for states. But what about territories? What about the existence of territories such as the District of Columbia or conquered lands, conquered and confiscated lands as the nation expands westward. So I'm on slide number 4 now, and we're going to go over 3 basic positions, and there are 3 views of this question. One view, the dominant view, the understanding that's acted on and practiced and put into effect is that Congress has plenary power to govern the territories, and it can regulate or ban slavery in those territories as it sees fit. Logically, this makes a lot of sense, and it has firm textual support in the Constitution. So logically, if there is no state, and there was a prior Supreme Court opinion by Chief Justice Marshall that basically said this, for these territories, Congress logically has all the power that a state would have if a state existed, plenary police power to govern, only within the limitations of the Constitution, and all the power it itself has under the Constitution. So if there's no state, then it falls to Congress to decide whether there will be slavery or not. Textually, the Constitution does seem to say this makes sense. So I'm on slide number 5, and we're going to look here. Very important pair of provisions in Article 4, Section 3, and clauses 1 and 2. Right. So it's Article 4, Section 3, clauses 1 and 2. Clause 1: new states can be admitted by Congress. Right. And this clearly contemplates that the conquest of territory will be for the purpose of admitting new states. This is pretty important. For a long time in our history, it was thought that the Constitution didn't allow colonization. It didn't allow the United States to hold colonies in perpetuity. The conquest of territory was with an eye toward the admission of new states, and there would be processes for that. Article 4, Section 3, Clause 2, however, says that with respect to those territories, I'm going to read this provision. I'm on slide number 5 again. The Congress shall have power to dispose of and make all needful rules and regulations respecting the territory or other property belonging to the United States, and nothing in this Constitution shall be so construed as to prejudice any claim of the United States or any particular state. Okay, so the kind of ordinary meaning way to read that is that Congress has the power to govern the territories, all needful rules and regulations to legislate. You could read it more narrowly if you wanted to, if you needed to, or if you had a theory that told you that you should. You could focus on the words belonging to and say, well, this governed only what they had in 1789. It says the territory or other property belonging to. Is it limited to that? Well, it depends. This is going to be important when Tawney addresses the second issue. Can Congress ban slavery in the territories? But the understanding generally was that it could, that it had this plenary power, and that the constitutional source of that power of Congress over the territories was Article 4, Section 3, Clause 2, which we just read. Slide number 6. So Congress can do what it wants. It can have 2 policies. It can ban slavery in some areas while allowing it in others, as it did with the Missouri Compromise, also known as the Compromise of 1820. In that compromise, Missouri came in as a slave state. Maine was carved out of Massachusetts to come in slightly later as a free state. And then they drew a line. They drew a line at the southern border of Missouri and said that this is the Missouri Compromise line. And drawing it westward above that line, and Missouri sits above that line, but it would be coming in as a slave state. Above that line, slavery would be banned. Below that line, it would be permitted. As I said in class, this sounds kind of asymmetrical, like banned in the north and silence in the south. But it really isn't, because westward movement sort of tracked regional culture, practices, and relationships, and people migrated west in the southern part of the country. They brought their slaves with them, and slavery was established, by the facts on the ground. Another wrinkle here in this plenary power Congress has to govern slavery in the territories involves what it can do with that power, and this is true generally. If a body has power, it can usually delegate that power to someone else, and we get into questions about what's being delegated and what isn't. But Congress can and will increasingly have an incentive to say that someone else gets to make the decision about slavery in the territories and whether a state will be coming in petitioning as a slave state or a free state if it petitions to come in as a new state, right? So in Stephen Douglas's hands throughout the 1850s, this became known as popular sovereignty. Congress won't decide. It'll let the people themselves, the white people, in those areas decide whether they want slavery or not. It sounds very nice. It sounds very democratic. Which people decide? When? Through what process? Through a territorial legislative body, or only when they have a convention to write a constitution to come in as a state? It can get complicated. But that's the baseline and predominant understanding. Congress has the power, can do what it wants, it can have two policies, it can delegate its power to decide. But I'm on slide 7 now. You can click through the animations here. This is an important general phenomenon. A lot of times when issues become vital, central, highly conflictual in American politics, people have moral and political incentive to constitutionalize those issues, right? So issues that aren't regarded as matters of constitutional resolution or even concern become framed in arguments about what the Constitution means. And of course, if the Constitution requires something, then no majority of the moment can override that with ordinary legislation. That's the idea of having a Constitution. So think about contraception and abortion in the late 19th century. No constitutional concerns or issues or fights about contraception and abortion. That issue becomes constitutionalized as other cultural and economic developments start, creating these issues in the system. Same-sex marriage. It would have been absurd as recently as 1970 to say there was a constitutional right to same-sex marriage. But now that's what we understand the Constitution to mean. So in this instance, with respect to Congress and slavery in the territories, there emerges over the course of the 1840s and much more in the 50s, I want to say, two constitutional arguments, and they're the mirror image of each other, right? So you can see the polarization and how this plays out in constitutional argument and debate. They make this question into a constitutional question. So I'm still on slide 7. The second view, the anti-slavery view, is probably best called the free soil view, right? So the slogan of the Republican Party when it formed in 1854 was free soil, free labor, free men, right? And this is an argument about economic development, political economy, and its relationship to freedom, and how free markets, the freedom to buy and sell land, free labor, you own yourself, you own your labor, you decide whether to sell it for wages or not, and freedom, individual freedom, how that's bound up with morality and freedom and, what the country is supposed to be about, right? And this is the ideology that, wins the day in the war and carries through after the war. Free soil, free labor, free men. The land conquered by the United States had to be free for development and buying and selling. You didn't want that land gobbled up by a few oligarchs who owned massive plantations and armies of slave labor. That created a certain kind of economic inefficiency and a certain kind of culture, a culture about hierarchy and domination and subordination, not the kind of culture that was increasingly embraced in the commercially developing North. You see in the excerpt I gave you from Doris Kearns Goodwin's book, the 2 or 3 pages of the Seward's trip through the South and how they looked at slavery, you see William Henry Seward he's kind of looking at it as horrible economics and his spouse is, horrified, sort of morally horrified, and that's an interesting dichotomy in how they're seeing it, right? But it's his wife who says, I can't bear this. We have to end this trip through Virginia. So this second view also begins from a widely shared premise, and the premise is slavery is unnatural. It is wholly and solely a creature of positive law. Yes, states can have it, but they have to do it by legislation. And if it doesn't exist, it can't exist without a state government enacting it, right? No states, no slavery, period, right? And on this view, the Constitution nowhere gives Congress the power to set up or to allow to be set up new slave territories, right? Slavery is unnatural, right? States can do that, but the national government cannot. So on this view, the Constitution requires no slavery in any territories governed by the United States. The only way slavery can be extended is by a state. Now, given, as we've just said, the long history of Congress doing just that, allowing slavery to exist and supporting it in certain ways, in certain instances, we have to view this view as substantially aspirational, but viewing it that way makes us kind of confront this interface that's important still, between moral claims on one hand and the invocation of authoritative legal materials or norms given from the past on the other, right? I mean, it's not just a moral religious claim. It makes a claim to constitutional meaning. So what authoritative legal materials might there be on this claim? Well, I'm on slide 9. Next slide. Well, it would reach back to the Declaration, which is not technically part of the Constitution, but politically, rhetorically, historically, it's often invoked. Lincoln invoked it. Martin Luther King invoked it. We hold these truths to be self-evident. And then you can read the preamble, and Frederick Douglass often did, to say something broad and general and moral about the purpose of the Union and why the Constitution is what it is, and then argue that you read more particular provisions and ideas and norms in light of that, right? So to secure the blessings of liberty. Slide number 10, this is a third view, and this is the Southern view of Congress's power. This is the view that Tawney endorses when he deals with the second issue in Dred Scott. It is the mirror image of the free soil view, right? On this view, and you need to understand the philosophical foundation of Tawney's opinion to even entertain the idea that he's rendering a plausible legal interpretation. He has a theory of the Constitution and a theory of the Union. And on that theory, the states are central, and the national government is the agent of the states. So the Constitution, read properly, and we've talked about this, right? We've looked at the provisions that have to do with slavery and their ambiguity, but Tawney's view is the Constitution clearly, in its intent and purpose, endorsed slavery because it acknowledged it and protected it. It's maybe an extension to say that the framers viewed all African people as a degraded race. That's a more controversial claim. But the argument here is that there is no power existing in the Congress to get in the way of slavery, ban slavery, or even regulate slavery, right? States and only states can do that. But the Constitution is kind of a pro-slavery document in its actual provisions, right? And certainly the Constitution was all about the protection of private property, right? So if we're talking not about free blacks and slaves, but slaves are centrally talked about and viewed as property, not persons. Little problem for Tawney is that the word used in the Constitution is person, not property, but that really depends on whether we focus on what they wrote or we have some evidence about what they meant by what they wrote. All right, so on this view, the Constitution follows the flag, and slavery is protected under the Constitution. So where the flag goes to a territory, so too goes the Constitution. And where the Constitution goes, so goes the protection of rights and the protection of those rights from abridgment at the hands of the central power, the central government. Okay. Now, next slide is slide 11, and this returns to Article 4, Section 3. And I'm just going to flag as a preview, when Tawney gets to the second issue in Dred Scott, he limits what seems to give Congress the power by reading it narrowly, saying it's a provision. The idea that Congress can make all needful rules and regulations is a provision just for this time and place and just about the territories that then belong to the United States and not future territories. So he parses that language to support that view. But really what's going on here is this theory of the Union that the only purpose for having territories is to admit new states, right? So he focuses on the power to admit new states as an authorization to have territories, but not that Congress has plenary power to govern those territories. The whole purpose is states. And again, when it comes to slavery, states are sovereign, right? But Congress is powerless to limit slavery or ban slavery in jurisdictional areas it controls. Right? And another thing on the second issue, and I'm on slide 12. So here's the Fifth Amendment. Now, is a slave a person or property under the Fifth Amendment? But Tawney's argument is if your constitutional rights go with you to a territory and they include the protection of your property, then you have a Fifth Amendment right not to have your property taken from you without just compensation. So he relies on both of these things, that Congress lacks the power to ban slavery and that the Constitution itself protects your property rights when you travel to a territory. All of this is controversial. It's not clear that when you go to a territory you bring the property law of your state with you, but that depends on whether Congress can intervene or not. So those are the three views. Congress has plenary power. It can delegate it if it wants to. The free soil view, Congress may not allow slavery in the territories and has no constitutional authority to do that. And the Southern view, which is that Congress cannot ban slavery in the territories. It has no constitutional authority to do that. As the slavery issue in the territories heats up in the 1850s, we see the disintegration of the existing party system. We've talked about this in class. Both parties, the Whigs and the Democrats, are organized north and south. They're trying to avoid the issue, then they're trying to compromise on it. The compromise of 1850 is really the sort of last gasp of compromise, and we talked about that in class. Slide 14 has a map of the United States as of 1851, and in that map you can see the vast region in the middle of the country that's not organized, right, is not governed yet. And the Civil War really starts just west of Missouri in the territory now known as Kansas, Nebraska. What's going to be the rule there? In 1854, another kind of compromise, but this actually repeals the Missouri Compromise, because if you look at slide 14, you see that a lot of this territory is above the southern border of Missouri, where slavery is supposed to be banned. Does that line extend there? In 1854, Congress erases that line. That line is no longer a rule and endorses popular sovereignty, right? That the people in the Kansas-Nebraska territory would decide the issue. People in Congress are increasingly cognizant of the constitutionalization of the problem. They're increasingly maybe wishing that the court will intervene and say the law of the Constitution. So when they write this legislation and other legislation, they keep inserting the phrase, here's the rules subject to the Constitution, without saying anything precise about what the Constitution means on the question of slavery in the territories. So I'm on slide 16 now. This is the Dred Scott case we're going to talk about, and this is the fraught context of it. So there are a couple ways to look at this case. One way that's common in political science more than history or law is to view it institutionally, right? When political scientists study the Supreme Court, they study it as a political policy-making body. It has to work with different tools and arguments, but it's essentially an agency in the governing process, like others. So on this perspective, the thing that's wrong about Dred Scott is not the legal argument so much as no court should ever intervene to try to solve a national crisis, right? This is just not an appropriate issue for the court. So what was wrong about it was an stupid activist decision. Court could have easily rendered a more narrow decision. It could have easily ducked. There were lots of ways to avoid these broad pronouncements on the burning issues of the day. Court didn't do that. But the court itself had been promoting the idea since its founding that it was the final word on the Constitution. So maybe there's a sort of a belief in that. Chief Justice Charles Evans Hughes once called Dred Scott the court's self-inflicted wound, like a wound that didn't need to take place. But Tawney, at least, is trying to convince us that he's got it right, that this is what his duty is. It's not like he has a choice. He has to interpret the Constitution of the United States by his best lights. This is his faithful and accurate interpretation of the Constitution. He is following the law. So to evaluate this claim, we first have to follow and evaluate the quality of his argument, right? Is his reading of the Constitution even plausible? Is it the best one? And if you think it's not, if you think it's a politically motivated hack job, then you need to say why. You need to say what's wrong with his legal argument. You can maintain that he shouldn't have said anything, fine. But we want to at least follow his argument, right? So now I'm on slide 18, and we're going to, I'm going to do a second video. So I'm going to stop this video here. So this video takes us to slide 18, and I'm going to create another video because I've been going on a bit longer than I anticipated. And the second video will cover this procedural history, and we'll do a flyover of Tawney's argument. We'll dig more deeply into it when we get into class. Okay? Be back in a minute.